Today we are talking about 65B of Evidence Act. As we all know what is Evidence Act, two important terms we need to be aware of is one is evidence. In common parlance, it is a proof. Proof is something that you give to the court to tell that your story is true. And second term is admissibility. Now you cannot submit everything in the court. There is certain restriction and there is certain norm as to how and what you can produce in the court as an evidence. So now let's see what is 65B of Evidence Act and how it is related to Information Technology Act. 65B of Evidence Act is an amendment in the Evidence Act of 1872. Now, since you realize that it is 1872 Act, obviously there was nothing electronic at that point in time. We had no cell phones, no pen drives, no CDs, no floppies, nothing of that sort. So as and when the advancement in technology took place, there was a need for making provision in the Act to validate certain information in other format. That other format is electronic in nature for today's discussion. Also, there was a need for storing huge data. Like say, for example, you have a big recording, but is the whole recording important for you in the case? May not be, but you have to store the whole data. So there was a need for that. 65B basically focuses on admissibility of this electronic evidence that we are going to talk about. As per Supreme Court directions, when the court realizes that there has to be a certain provision, because at that point in time, there was no provision as to how and what type of electronic evidence can be permissible in the court of law as an evidence. So when one case came up, and they realized that there was some need, they made certain directions, and then there was subsequent amendment and changes made in the relevant acts. Now, this has also led to improvement of cyber jurisprudence. And this basically, why we are talking about admissibility, because whatever that is produced in the court has to be authentic, and we have to confirm that authenticity or veracity of the proof or the evidence that is produced in the court. See, being in the court, going through the litigation, having a proper case trial going on, this is all a serious business. It's not just something that is done every other day. It is a serious thing. Somebody's life may be at stake. So it's very important to have an authentic evidence on record. And whoever is submitting or producing this type of an electronic evidence, the person who's authorizing it or certifying it, we're gonna see that later, has to produce a hash value report, which is a very technical term, but there is something called as hash value report, which is submitted along with the electronic evidence to prove its authenticity. Now, what are the various formats that we know? It may be audio recordings, video recordings, maybe in a CD, DVD. Okay, now these days we don't talk about floppy. I think when this changes or these amendments were made in the relevant acts, floppy had already gone. So wherever you see whatever material you read with respect to electronic evidence, you will see that there is CD, DVD being mentioned and no kind of floppy disks mentioned. Also, there is pen drive, which is very famous and common with us. Call recordings, it could be a voice recording, could be a video recording, that's the CCTV footage, it could be a WhatsApp video call, it could be an email. So these are various type of formats which are admissible in the court of law as an evidence with respect to electronic evidence. But what is the certification part and what are the certain restrictions or the norms that are to be followed to authenticate these evidences is what we are going to see today. Now, there was this Supreme Court judgment which came into light, Arjun Panditrao Khotkar versus Kailash Kusanrao Gorntayal and others. Now, that is the judgment which explained about the requirement of a certificate. So how are you going to say that whether this is authentic or no? I must just come up with a WhatsApp chat, which could be fake, And you never know. I could come up with a call recording, which could be an edited kind of a thing, and that is not true. The voice, whatever the voice says, may not be true. It could be just something different. So, and it is possible to do all these things. Okay. So that's why Supreme Court said that no, there is a requirement of certificate to be produced when you are producing electronic record in a printed format. And it also explained why it is imperative. As I mentioned these reasons, there are some reasons. With advancement of technology, let me tell you, there is a whole lot of plethora of things that can be done, and how you can actually do mischief with electronic things has become a big area of study today. The reason also being that cyber crimes have increased is the same thing. How people are getting duped. You might be hearing about it in the newspapers, how people are getting their money transferred. Everybody is telling you every now and then, don't share your OTP. That's one of the reasons why this whole thing has come to light. Now, also it mentions what stage it should be furnished, if at all, in a trial which is going on, or an appeal that is being held in the High Court. So when are you supposed to produce it? That also the judgment mentions. And from here, the whole thing, the discussion, the changes about electronic evidence being produced in the court started. Now, there's one more interesting judgment called State NCT of Delhi versus Navjot Sandhu, which talks about the requirements mentioned in 65B. And also it says that even though you have already complied with the requirements of 65B, there is no bar as to what and how you can produce it as a secondary evidence under section. For this, you will have to really go through 63 and 65 of Evidence Act. In simple parlance, if I have to say for example, a woman has filed a case of domestic violence against her husband and his parents or his family. The lady produces, say, for example, a CCTV footage that she's being harassed physically, mentally. You can see in the CCTV, in the footage. But if at all she has some other evidence, for example, she has, say, a very good sister-in-law who is ready to say, oh, yes, she's being harassed. Maybe her mother, she has written some letters, made some phone calls that, I'm getting harassed in this house. They are saying such and such thing. They are taunting me every now and then for various reasons, maybe not working, for not having a job, etc., etc. So she can bring them as witness in the court. So there is no bar as to what kind of evidence you can produce apart from the electronic evidence. You have a CCTV footage which is directly, you can see that things are happening in that video, but that doesn't mean you cannot provide other evidences which will support your case. Now, there is another judgment, Anwar versus Bashir, which actually overruled State NCT of Delhi versus Navjot Sandhu. Now, this is a very important case as per electronic evidence is concerned. You may go through it and you will realize how electronic evidence was considered in the court, wherein the veracity, the authenticity of the electronic evidence is challenged. Say, for example, you have produced the CCTV footage, but obviously the person who is supporting, the advocate who is with your opposite party, is certainly going to raise a doubt in the mind of the court that no, this is not the truth, but the truth is something else. And they may show other CCTV footage. Now, I've come across such a case wherein there were two parties, both were husband and wife. The wife's advocate was saying that she is being harassed for the custody of the child by the advocate and the husband, and he produced a pen drive in the court. And the lady advocate who was with the husband, they both produced a pen drive saying, no, see, we are being harassed for the child's visitation hours by the wife. And you will clearly see in the pen drive how things are happening. So, see, one person is not going to produce pen drive or CCTV footage, but even the other side will be. So, whom to believe? You can't leave everything to the court. People challenge, right? They may give some other evidences. So how the electronic evidence is challenged and how to manage that is something you will learn from this judgment. Now, there are two other judgments also which you can read, go through, and you will realize that Supreme Court has taken cognizance of electronic evidence to such an extent that it will give you a clear picture, or rather it will put you to thinking whether the electronic evidence should be or is produced in the court would be true or no. So you can go through these two judgments, Tomaso Bruno case and Shafi Mohammed versus Himachal Pradesh. These are very interesting cases. When you read, you will realize how electronic evidence should be or should not be produced in the court, and whether you say, okay, I have a video footage, but should you really give it in the court is something you really have to put your brain to. So these two cases you can go through. Now, coming to 65B, there are certain clauses in it. The first clause talks about electronic information that is recorded, which is contained in any electronic record. So basically, the information could be as anything as such we discussed. It could be a voice, or it could be a video, it could be a WhatsApp chat, whatever that is. So that is any information that is contained in the electronic record, and it is produced. Obviously, you will submit the pen drive for maybe the judge to see, right, to watch the video and come to a conclusion. But how do you put it on in record? So record is basically the case papers or the brief of the court. So you have to produce it in the printed format on a piece of paper, and whatever that is recorded, stored, or copied in optical or magnetic media is again deemed to be a document. It is considered as a document, but it is put down on paper as well for the concern of being it on record. And of course, it has to meet with the requirements of clause B2 of the Act. Now, what is section 65B2? So this data that is stored, recorded, or copied, they are saying it can be produced in the court, and it has to validate certain requirements. It cannot just be produced. So this certificate thing that we are talking about is the basic requirement which is given in 65B, that it has to be authorized. Say, for example, you are collecting certified copies from the court for doing maybe putting it as a revision in the sessions court. So you have got the certified copies from the trial court. You will always see that there will be some stamps. There will be a judicial clerk who will be signing on it, on certain papers which are important, and they will be putting a seal of the court on every page. So what are they doing? It is basically a Xerox copy, right, of the original set of papers that is in the court. But when you take it, a Xerox copy, a photocopy is not an evidence. It's not admissible in the court. You may just take a Xerox copy of anything, but it has to be validated. You can just add any papers. You will just Xerox some other papers and maybe add into it. So how is the other court where you are approaching going to understand whether it is a part of the original court record or no? So that is the reason why they put seal on each page. They stamp, there is a court stamp which they put on important documents, and then there is a signature, original signature on that paper by the authority of the court, who is a JC. So that's how it becomes admissible in the higher court. Now here, similarly, when you have the data in, say we are talking about CCTV footage, there's a video recording that is being written down on paper that is called as transcript. Now that transcript has to be validated or authenticated by an authorized person who can do the, I mean, he's the authority who can authorize. It's not just you and me doing it. And then it becomes admissible in the court of law. Also, 65B talks about successive operation for connected computers. Now, if say, for example, you have 3-4 computers which are connected and there is certain flow of information through all of them. So this is considered as one computer, and they are talking about successive operations. So it has to be connected. It can't be in bits and pieces. So maybe there is a server or a big firm where many computers are connected and there is flow of information. It has to be a flow and it has to be in regular nature. And that's how it is considered as information collected from one computer. That's a slight thing. Now 65B4 talks about a statement which is sought in evidence, and that has to be considered as an electronic record, that has to be identified as an electronic record. Also, it should mention all the particulars of the device. Say, for example, there's a pen drive out of which you have got the video. So it has to mention the details of the pen drive. Like if, for example, you know that our phones have IMEI number. So pen drive must also have some identification number, which the expert may put down, may write the make, say it's a Seagate hard disk, something of that sort. So any device that gives that information, which is produced as evidence in the court, that device, particulars of that device is also mentioned. There are lots of pen drives in the market. Which pen drive are you talking about? There are lots of phones in the market, but your phone has only one specific or particular type of number that is called as IMEI, which is unique to the device. So this mentioning of particulars of the device is very important. Also, identifying the electronic record is important, and production of evidence has to be done by a responsible official, and that person has to be the person who has operated the device. It's not that, say for example, I am the cyber expert, I have checked your laptop if your laptop is hacked or no. So I have a specific software through which I will come to know, and I will check that. I give a hash value that is being given at the end, and I will produce it. But then you cannot just produce in the court saying that this is the evidence. I will have to go. I will have to authorize it. I will have to certify it, and I am the responsible official. So tomorrow, if there is a, say for why we are doing all this, basically tomorrow, if there is something wrong in the evidence, something fishy is produced, something that is not true, then I will be held responsible. The person who's authorizing, the official who is certifying the electronic evidence, will be held responsible for authenticating that as it's wrong, right? And he has certified or authenticated is that right. So that person will be held responsible. We are doing all this just for that purpose. Now, for understanding 65B, it is important to understand Section 67C of Information Technology Act 2000. So basically, they made provisions in this act as well to understand, and it always goes like this: section so and so read with section so and so of IT Act, because that act talks about what type of data or what is the process that is being followed. Now, data is huge. Okay, we are every day we are dealing with tons of data we don't realize. And this data has to be stored, it has to be retained, it has to be produced in a proper format. All of these kind of things, playing with so much of data is no joke. So IT Act makes provision for exercise of powers which is given in that section pertaining to retention. So for example, we are talking about CCTV footage, right? So this video recording, say, runs for around half an hour. But my relevant data is only 2 minutes. But I will have to retain the whole 30 minutes video recording because I cannot edit and give it to the court. I have to produce the whole thing, mentioning that the relevant data lies from, say, 00.13 to 00.15. So you know that you get a scale, right, of timeline on your video. So I'll have to mention that that's the relevant data, but I will have to retain the whole half an hour footage with me. So IT Act talks about a lot about storage and retention of data, because what happens is over the time, your device may not work as properly as it used to. Say, now here it is mentioned that it's for trial of offenses and appeals. Now, why are we talking about appeals? Say, for example, the trial is initiated in the lower court in 2020. By the time the trial gets over in the lower court, maybe it's already 2023. You really think your pen drive is going to work as nicely as it was in 2020? Yeah, in 3 years, nothing will happen. It's going to work fine. Let's go ahead. Then there was an appeal. They went to high court. Then there will be loss of again, say 2-3 years. I'm taking it very short. 2-3 years is very less actually. You may also be aware, but let's take it as 2-3 years. So again, you went in high court. 2-3 years are gone. 6 years, okay, right from 2020. And then somebody approaches, says, no, this is wrong. This is an injustice done to me by the high court. I am approaching the Supreme Court. So again, that kind of time. So by the time your matter is listed, by the time they will maybe retain the whole thing and look at it, maybe 2 years are lost, say, for example. So what is the timeline? It's right from the lower court where you started till the Supreme Court, it's 8 years. So in that 8 years, anything can happen. Being in India, we live in a very humid climate. Things go wrong. You might have seen your phone, your laptop, your pen drives behave weird sometimes. So all kind of things are there. And how much soever care you take, it is very much possible that something goes wrong. Or maybe someone has done something wrong to it. Again, now here people are going to interfere, right? So external factors are endless, and during the trial or even after the trial, retention of this data is a big responsibility. Also, conservation of metadata to avoid corruption. Now, your data gets corrupted sometimes, suddenly. Suddenly you say, oh, my laptop is not functioning, something has gone wrong. So, you know, metadata is something that gives you information about other data. For example, there are these keywords. You type in section 67C of IT Act in Google and you get a list of links. So what is that you type? It is a keyword. It's a metadata that is connected to the other links, as in web pages, which reflect that information. And most of the times it is correct, but if you scroll through and go 3 pages ahead, you may find even irrelevant data. Why? Because maybe it is just mentioning 67 somewhere and you get the page. So what I'm trying to say is there is a lot of information behind that information that you are searching or that you are holding in with you as evidence. And data getting corrupted is like something that can happen anytime, anyhow, and then it can happen or somebody can make it happen. So conservation of all this is very important, and that's why they are talking about conservation of metadata also. This is a little technical because we've gone into IT Act. And of course, separation of data. So if, like, for example, I said I have half an hour video recording and only 2 minutes is relevant. Maybe going ahead, they say, no, separate the data and give it because we have already seen this and we only want the relevant information in the higher courts, of course. So that separation is, you can't just edit, cut like that and give it. So you will have to follow a procedure. You will have to authorize that it is being done in front of me. I have done it. You have to sign it, certify it, and all those kind of things. So IT Act, understanding these sections is very important to understand 65B as to how the electronic evidence becomes permissible in the court as far as admissibility is concerned. Section 59 in Evidence Act was modified to exclude proving of contents of documents. So basically, any electronic evidence that was being produced in the court was to be justified by an oral evidence. Say, for example, I am the cyber expert. I have done everything. I have given a, say, certificate or relevant information to the prosecution, that's the police. But then I will be called again by the court to say, yes, this is my sign. Yes, this is what I had given, to validate it. So that's the oral evidence I am giving in the court to prove that, yes, this is the document that I have certified and I have validated. So section 59 really removes that. It excludes proving of these contents of documents. It's not important to for me as a cyber expert to go to the court and prove the contents. Maybe they call me to verify that the sign is mine, that the document is something that I have produced, only to that extent. Earlier, there was a need. Now, there is not after the amendment. Section 22A, of course, you see that A, so that's something that is something that is inserted later. It provides for oral evidence being relevant only when the genuineness is in question. Say, for example, there is this lady we were talking about who's facing domestic violence at home, and she has produced a CCTV footage. Contradictory to that, her husband has provided some other CCTV footage which shows some other picture. So whom do we believe? And then we can have someone witness who can come to give oral evidence. Now, when the genuineness of that record, whether this has to be believed or that, whether this is edited version or this is the original one, we have no idea, right? We are the bench, we are the judge, and we are trying to evaluate the evidences. We don't know. So at that point in time, oral evidence will come into picture. A witness may come and say, no, the wife is lying, the husband is truthful. Whatever he has produced is right. Now, this is a family matter. Say, for example, it is very technical. An expert has certified and authorized the evidence which is produced in the court. Now, I have come across a case where there were a lady happened to die, and she was a very rich woman. Like, her property ran into crores. And there were two families who were fighting over that. One party produced a will saying she has left everything in our name. And then the second party also came up with a will saying that this is what is in our name. They are not truthful. Our will is right, their will is wrong, all those sort of things. So at such point in time, we will have an expert who can validate the will and come and testify in the court saying that this is genuine and the other one is a fake document. So similar thing can happen in electronic evidence, and we can have the expert testifying in the court that yes, say for example, record A is genuine and record B is fake evidence. So his will be an oral evidence in the court of law. That's what section 22A is talking about. Now, section 45A is inserted to provide for opinion of examiner of electronic evidence. Now, who's an examiner? The one who is dealing with this electronic evidence, the one who is certifying, as we were saying, who is validating the document that, okay, say for example, there's this CCTV footage. I, being the cyber expert, I have seen the record, I've seen the video footage, and out of half an hour, these 2 minutes are relevant, and these 2 minutes are what actually the person got, say, stabbed. So you may have a CCTV footage or CCTV camera which is fit outside the house of the person, and there is somebody who's going and some servant is entering the home. This lady of the house is the owner. She has gone out. Maybe she came back with some veggies. All these kind of things are recorded in it. Okay, so you understand that it's a continuous recording. It's a regular and continuous recording. But out of that, in 2 minutes, she ends up going to her doorstep. She's just there, maybe holding the handle of the door, and she's going to open it, and someone rushes towards her from behind. He stabs her and runs away. And she gets killed. She's dead now after 2 minutes. So this incident of she holding the handle of the door and the person rushing towards her with a, like, say, huge knife and stabbing her is the relevant part of the whole evidence. And the person who's going to examine this, he is supposed to give his opinion, and that will be relevant fact under section 45A when the court has to form an opinion on the matter relating to the information. It simply means that the opinion of the examiner becomes important, or it becomes relevant fact. Now you'll have to see what is relevant fact in Evidence Act to understand how what is the scope of relevant fact, I mean. And the opinion of the examiner becomes relevant when the court also has to form an opinion on that matter, whatever is like seen or read. It's not just the CCTV footage, it could be a WhatsApp chat. So that's what it means. And we are talking about section 79A of IT Act. Now here that it's very important to understand, we have been talking about examiner of electronic evidence. So me being a lawyer, can I be the examiner? No, because I have no knowledge about the IT Act or how the electronic information runs through. There has to be some expert, someone who's done those kind of say courses or diplomas or whatever the requirements are. So this section 79A very specifically tells us, this is from IT Act, not from evidence, please note. They talk about who is an examiner of electronic evidence. So basically, he is an expert who is gonna give his own opinion on the electronic evidence, whatever that is submitted, and that the person may be from a central government or state government approved or a department of the government body or an agency. Department and agency is a little different, but they are all a part of the government, you can say. So basically, they are authorized by the government. They are not just some other person. Maybe they are getting some, there may be some provisions, some criteria they fulfill, and they become a part of the whole process. So they are like validated examiners, and they are validated by the government itself. Only these people can become examiners, and these people are having the capacity and the validity of giving it in the court of law. You and me cannot go in the court and say, I have examined the electronic evidence. So mostly these are experts, cyber experts, or some other experts who are able to do this. Now we will be talking about this certificate. Certificate to do what? To prove or to validate or to authorize that electronic evidence from that particular device. Now, there are certain trusted third-party people also. These people do have a team of experts who do it for them. Second is certification should show that the evidence is genuine. See, basically, why are we doing this? Because whatever evidence we have given in the court of law has to be genuine, and it has to be proved to be genuine because it is from another device, right? It's not like, say, for example, your mark sheet that is validated by your college or your university, wherein you have all those stamps and signatures. There are electronic signatures on your mark sheets, if you have noticed. But we all know that the person who has validated is such a person who is an authority in that institute. Say, for example, there is vice chancellor of, say, Mumbai University or any other university. You might have seen that the person's electronic signature is being printed on your mark sheets. So that's the certificate, right? So it's a very simple term, nothing much to understand in that. Also, it is a person from whose electronic device the evidence is procured is very important. Say, for example, it's my phone. So I have to be present at that point in time when the expert is evaluating or actually examining my device. So certificate should reflect that the person from whose device that evidence was procured was there, or whether he was there, or there's something called as panchnama that you do in criminal trials, and there are certain norm, as in you have to have two third-party people, some unknown people who are called punch, and they sign on the panchnama saying that this process was conducted on such and such device in front of me, and whatever that the expert is saying is true. It's not just left to the police and the expert. There is some other person also who's witnessing the whole process. Because the person whose device it is, the person may not be in a position to validate it, or he may not be considered as a proper person. Maybe the person is an accused. Are you really going to believe what the accused is going to say? No. So that's the reason why. Now, signature of that same person, the person who's validating it, is important. His signature is very important. And there is, I've come across a question where they asked that what is there any format, specific format for the certificate? There are various formats. There is no such single format, but I'm going to show you a simple one in my PPT going ahead. So we are talking about admissibility. Now, admissibility means what? It just means that whether your proof, your evidence is correct enough or truthful enough to be considered in your favor as an evidence in the court. That's what admissibility means. Simply whether you're giving a right proof or not. So certificate certainly identifies the electronic record, saying that, as we took an example earlier, say for example, this is a Sony hard disk, okay, number so and there was a stored video footage of half an hour, out of which these 2 minutes are relevant. So it talks about the device, its details, particulars, then it talks about what was inside it, and it also talks about what is supposed to be taken as an evidence in the court of law. So it should mention everything. It should identify the whole. This whole thing is an electronic record. So I'm wanting to point out that only the device or only the footage, only the phone, IMEI, along with IMEI, only the WhatsApp chat, it's just a piece of the whole thing. So this whole thing is an electronic record, and the person is supposed to certify the whole thing. If he has failed to do so, then it will not be considered as an evidence in the court of law. That only means that it is not admissible. Secondly, certificate must describe the manner in which it was produced. The manner is that only. Say it's a pen drive, it's a hard disk, it's a phone. So from where did you get it? That's very important, because if need be, tomorrow going ahead in the trial, if it is under question, you can actually backtrack it and you can retrieve information. Even if it is deleted, there is certain elaborate process that these people follow, experts have, and they can retrieve the information and validate it again. So it has to describe the manner in which it was produced, so that they can retrieve and again work on the evidence if need be. Next is certificate must furnish particulars, as I mentioned earlier. And also it says that the certificate as to when, what stage when it is to be furnished is not mentioned here, okay, in 65B. Basically because when the trial starts, you don't know how the witnesses are going to be produced, how evidences are going to be given. Of course, when a criminal trial starts, the police files a charge sheet and evidences are to be given along with the charge sheet. But you may not be aware that a bank statement, being for example, a bank statement is a confidential information. Okay, it's the very sensitive data with respect to a single person. Now it's my bank account and my bank statement. How much money do I have? How much money has got transferred where? What have I done with the money? Is all my thing. It's my confidential data which cannot be produced in the court for everybody to be displayed, right? So this has to be kept as is with the bank, and bank will never give you such details. What will happen going ahead in the trial, when the court summons the bank officials, the person, the authority, whoever that they have, say for example the manager, bank manager, branch manager, he will come with the statements duly signed, stamped, certified by the authorities, and he will produce it in the court saying this is this, and you may go through, and yes, I am validating that such and such transfer of money has happened. So what is the stage at which it is to be furnished is not really mentioned. It could differ from one case to another. Say for example, I'm telling you about one case. Now there is this guy who actually is a fraud, and he connects with some girls or women and dupes them for money. He says that I am in need of money, please give me this much money, that much money, and they just transfer. Okay, now this transfer maybe into lakhs has already happened from her account to his account or some other account that he has told her to transfer the money in. Now, this whole thing is a sensitive information with respect to that girl's account. And when it is to be produced in the court is where the court applies its mind. The judge will say, okay, now summon the bank official. We are at the stage that where bank official has to be present in the court and give his, as a witness, give his oral evidence and say that, yes, this transfer has taken place. Such and such, say 30 lakhs have got transferred from account A to B on such and such dates in so many installments, say 5-6 times the transaction has happened. So he will come and validate it. So now what stage it will be, that the court will decide. That's why it is not mentioned anywhere when it comes to 65B of Evidence Act. It talks about certificate and admissibility, but it does not talk about the stage when it has to be given or furnished in the court of law. Now, I've given a format, a simple format for you to understand what kind of certificate is given in the court. So this, of course, mention I so-and-so advocate. This is a normal format in the court of whatever, what jurisdiction, in case number so-and-so, this versus that, plaintiff, defendant. Okay, now I have given here a civil court. So it's a civil matter. That's why I've mentioned plaintiff and defendants. And the certificate simply says that I'm producing an affidavit for so-and-so electronic evidence. It talks about WhatsApp message here and emails, and hard copies are given. So that chat has to be like, you do a screenshot and then you take a print of that. Many a times I have seen lot of cases where WhatsApp chats are produced in the court as evidence, but that is electronic evidence. So you have to authenticate it from the person, because you can't take the phone to the court and see, okay, you can't give it to the judge and say, look at my chats, right? So you have to take printouts, and those have to be attached with an affidavit with a certificate saying that this is true from page whatever to whatever. You can read this later. And of course, very important, it bears the signature of the person who's certifying it. Of course, it mentions I so-and-so advocate by profession. I'm producing this, but the best way to do this is through some expert who does the job. There are third-party people who also do it, but most of them, they have certain authorization from the central or the state government, as we saw earlier. Now, we've been talking about all this so long. And why is this questionable? You may say, oh, this is just some video on my phone. This is WhatsApp chat on my phone. Why are we questioning it? And why are we talking about so much about certification, authorization? Why we need people, examiners? Why do we need experts? All those kind of things. It's just a chat on my phone. But the problem with it is it can be altered. It could be edited. It could be deleted. Anything of that sort can happen. When, say, for example, your phone is not with you, can't it be deleted? Can't a portion of your chat be deleted from your phone itself? When the expert examines your phone, he will say, you have only deleted the chat. Now what to do with it? So you never know what's going to happen. Now, say, for example, I have this case where a lady has shared some objectionable content about another lady, and the other lady has instituted a case in the court of law with respect to section 354 against that first lady. Now the lady says, I haven't done it. So when both the phones are in one room, can you really say that the lady number one has shared objectionable content? It could be handled by lady two also, purposefully. So these kind of things happen. They do happen, and there are a number of cases in the court of law where data which is already there can be deleted, is edited, or it is produced in such a way that, you know, the other person is thrown or shown in bad light. That's why all this data is questionable. All this evidence, why we need to really check the veracity of the evidence, because of these reasons. Also, you may be aware that there are so many sites or some computer programs or apps which let you do all this deletion, editing, and kind of things. And lastly, it is difficult As I mentioned earlier also during the paper, it is difficult to retain original data in devices. Sometimes you might just say, oh, my pen drive is gone bad. Maybe you just put your pen drive in your friends or your colleague's laptop, and the colleague's laptop had some kind of bug in it, and your pen drive is not working properly. Now what do? So you had some important data into it. Anything, it could be weather, it could be humidity, it could be water, you just spilled your coke, while working. It could be anything. So storage of data is a big question. Duration of storing data is something we don't know. You have to keep it because it's an important evidence. It has to be produced in the court, and you never know whether the person, see, when the say trial begins at lower court, you are not aware what is going to happen and after how long. And even after that, if the person goes in appeal, say in high court, then he goes in Supreme Court, you are not aware about the timeline. So the duration of storing this data is something which is no one knows, and it's very important to retain. So we are talking a lot about retention of original data. Original means it is unedited, or something that some parts are not deleted. It's the original information or the data that we have got as an evidence in the court of law when the case or the trial began. All that I would add here is being aware as a common citizen, being aware of what's happening around you, how people are duping others is very important. It goes into IT Act, and it also holds true with these provisions in Evidence Act. As far as a lawyer is concerned, I believe that knowing about 65B, knowing about certification is very important. Say you are a defense counsel and you have a case where this bank transaction I was talking about, that has happened, and you've seen that a lot of so hacking software and all that kind of process is being followed by the police. In this case, by an expert, cyber expert, I mean, cyber expert has validated it, he's given the certificate, he's done everything. But then as an advocate, you have to have a keen eye. Say for example, he has not signed it. Okay, he's done everything, he's given the hash value, he has evaluated the evidence, he has examined the device, all those kind of things, but he has not signed. So what you will do? That's your defense. You will say, okay, everything said and done, but it's not signed by the expert, so that is not admissible in the court of law. So knowing about this provision will help you mainly in criminal litigation, is what I see.
I would like to ask you one question that,
Yes.
there has been great advancement in technology. Many
Correct.
lawyers, we as lawyers are not aware about, these advancements. How can we keep ourselves well versed? Because submitting an electronic evidence, we need to have the technical know-how. So
Correct.
can you suggest something?
Okay, I'll tell you what I did. When I started off with criminal trials, I wasn't aware about 65B, to be very honest. And I came across this bank transaction case, and I realized that there was something which was mentioned saying that they will produce the bank statements later at the stage of the trial whenever needed. So I actually went out and I saw what is 65B. I asked the police. Okay, there were some other police officials who came to the court with respect to some other case. And I asked them. Also, I happened to take help of cyber expert to understand what is the concept behind it. So I think whoever you can, approach and know, of course, on Google also you will get a lot of information. Even if you type 65B, you will get a lot of very good articles which tell you in depth what it is. But apart from that, as a lawyer, I believe it's important to evaluate. So first you have to know what the provision says, whether the person is following the whole procedure or not. Like I said, there is no signature. You have to be very attentive in understanding that. But if you don't know that his signature is so crucial, how will you point it out? So knowing the provisions is first thing. Secondly, understanding the document, and thirdly, evaluating it is important. In process of doing this, if we don't understand one point of it, I think it is best to take help of experts. And trust me, there are a lot of people who are maybe the senior, some senior in your court, who is not an expert in that, but he knows that what, think with changing times. I'm telling you, it's not just, we have moved away from pen drive now. We have moved to, storing data on our phones, and there are a lot of data which is produced in the court, which is on the phone. Mostly it is WhatsApp chat. These people has verbally abused the other person, and the other person has said something. Lot of matters of that sort are coming. So I think keeping up with the technology, reading, taking help from your seniors or whoever experts you can really get into touch with is important. That's all you can do. Keep on
Okay.
upgrading your knowledge. That's
Yes, so IT knowledge is very important now, right? We can't ignore.
yes.
You
Hmm.
said that there is a central government agencies who validate and provide the certificate and authorize
Hmm.
these electronic evidences. My
Yes.
experience has been that they charge a very wholesome amount, even for the 15 second of one recording.
Hmm.
The client was asked to give almost 18,000 kind of rupees.
Hmm.
It to needed to be
Hmm.
paid. So, is there any because when we say that central government, so there will be
Hmm.
some kind of cost variation also
Yes.
associated with it. It must be available somewhere for reference that whether we are being charged heftily or is it as per the norms. My question is cost related. Like, is there
Ma'am,
any?
that we can't say. Now, even third party, how much they charge. See, if that evidence is that crucial to your case and you're gonna like it's a do or die situation, then I think you can't really do anything about cost, because it has to be authorized, right? The agency or the person who's doing it has to get authorization from certain government body, because otherwise, how it will be admissible?
Ma'am, one more thing. Like
Yeah.
if there is a call recording and the person about whom the recording is, the person is no more, like it's a deceased, then how the validation will take place? I just want to know just to make sure that the validation has taken rightfully in a right manner. In a call recording,
See.
there was a
Hmm.
panicking call from the
Yeah.
lady's side, but the lady is no more now. The lady's family has put up a case like they doubt that the person she was telling about in that
Killed.
panicking call has done
Hmm.
it.
Yes,
Hmm.
they can, that voice recording can be taken as an evidence, but you will have to give some supporting evidence as well. Now, since the lady is no more, you cannot do voice forensic. That's what you're trying to say,
Yes.
right?
How that will take
Right.
place?
So you can get her family members on record as witness to
Hmm.
say that she had called. They know, right? Mother and father know that the call had come. Say she will have
Right.
certain phone. She will, that number only will be reflected. Say now I am
Yes.
calling you, for example.
Hmm.
My
Hmm.
number will be reflected on your phone. You will
Hmm.
pick up. So you are an evidence. You are a
Yes.
witness to the
Yes.
call. So
Hmm.
apart from the recording, that's what we spoke about in one section, that there is no bar as to provide a secondary evidence along
Hmm.
with the primary evidence of electronic record that you are giving. So her
Hmm.
family members can be taken on record as a witness to that
Hmm.
incident. That panic call had come from her. Her number was there, and obviously there is a call record. You can ask the service providers. They
Hmm.
can give you the call recordings. So
So,
they produce. No? You may be aware. So
okay.
basically, if this is a criminal trial, as I understand from the panic call and all, then this has to be
Hmm.
done by the police. You will not
All
come
right.
into picture. Police
Hmm.
will do it, and they
Hmm.
will produce a, say, not call recording exactly, because tapping of phones is not allowed, and obviously we didn't know that it was a panic call when it came, right? But
Hmm.
they can always show the recordings on paper. Say for example, at such and such time, for example 1:35, the person had called her mother. So
Hmm.
you have those kind of records, no, which can be produced from the service providers.
Yes.
Does Evidence Act is admissible in family court as per section 14, as family court may accept the evidence with or without dispute, even if it is not relevant as per Evidence Act 1872.
If it is not relevant, it is not relevant. If it is relevant, the court will accept. Say, for example, there was a case where the person had filed a case against his wife on the basis of bigamy. So he had certain CCTV footage and he produced it in the court. It was admissible. See, we spoke about relevant fact even in this provision. So I think if it is not relevant and if the court is not accepting, you can't do anything about it. It has to be relevant, of course. Otherwise, it won't be accepted. It won't be admissible. You do certification, but your chats are not really coming up with anything that is supporting your case. It is not really a kind of an evidence. Then how will the court accept? People give all lot of sort of things. Now court can't waste its time like that. So of course it has to be that relevant, it has to be authentic, it has to be crucial. Like I said, the woman getting stabbed, that's a very important. Nobody else has seen, there's no witness, there is no other evidence, but still police will give evidence on record, such as the knife has his fingerprints. They will do forensic of the dead body. All those, it's not just the electronic evidence, you will have to support it with other evidences also. There's something called as circumstantial evidence and also something called as secondary evidence. I believe you should go and read that, how a whole trial or how whole case is built up. It is not just on one evidence, you have to furnish a lot of them.
I just wanted to clarify that if we are now, there are, like you said, there are going to be emails, because now a lot of communication is happening by email. And
Yes.
We have folders where we keep the emails there.
Right.
When you want to print the email, then there are two ways to print it. One is that you print in Google or someplace. And at that time, what I have noticed is that if you are sending BCCs to somebody in your email, that BCC is also printed on that. And obviously, sometimes we don't want the BCCs to be seen. So is there any way to avoid that, number one? And what is the best way to keep them, both the emails as well as WhatsApp messages that we are sending? How to store them? In the sense that can I take picture of my phone and store it? Will it be relevant, or is there any other way to do that?
Sir, I believe having a screenshot is the best, because a lot of screenshots are being printed and produced in the court as evidence. So if you want to store it for the purpose of a case or for the purpose of producing it as an evidence, I think storing it in such a format should be good enough, so that the person whom you call later on at the later stage to authorize or certify, it will be easy for him or her as well.
Okay, and then obviously he has to go through certification process, whatever the process might be.
Yes, he will go through the whole email. Say, for example, we are talking about Gmail. He will go through the Gmail on your laptop or computer, which he has, and he will see that whether it is true or not, and then he will take the prints and authorize it.
Then he will certify. Because whatever is written on the printout, because if you print a Gmail mail, then it gives you the date and time and everything on top.
Correct. Yes, absolutely. That's the whole purpose of authenticating it, sir, because time, date, in many cases, it's very crucial.
Most times when a phone call is being recorded by the other person, depending on the technology that the device uses, the other person may or may not be receiving an intimation that the phone call is being recorded. So, for example, I make a call to you and you are the recipient of that phone call, but before I commence talking to you, I initiate the recording of the call on my phone. Depending on your device's technology, you may or may not be informed whether I am recording the conversation on the phone call or not. Now, when such a phone call conversation is recorded surreptitiously, that I'm not telling you that I'm recording the conversation between us, but I'm still recording it. Is it an admissible evidence in the court, first of all? And second, despite my intentions of not informing you that I'm recording your phone call, I consider that to be a relevant information, the relevant exercise, because I believe that there may be something that you will say which is detrimental to me, and therefore I want to record that conversation and I produce it in the court of law. So is it admissible, first? And secondly, if it is admissible, am I required to also submit the transcript of that entire conversation?
Yes.
And third, in addition to that, do I also have to submit my phone to a certifying or an expert agency who will actually examine my phone and then describe that this conversation which I have recorded in my phone is
Yes.
a genuine conversation?
First thing, yes, it is admissible in the court if it is certified by the expert. Second, yes, you have to give a transcript. And third question is, you were talking about expert, right? Yeah, you have to give your phone. Yes. The person will examine your phone, because see, actually, as per my understanding, there is separate app, or there's separate provisions in the phone. Well, it's an embedded app which records the phone call. Now, in such cases, the other person is not aware. 90% times, the person is not aware. Secondly, you know that you're going to initiate a case if not already, so you're not going to notify the person. Okay, you want to catch me unaware. So you're not going to tell me I am unaware about you recording the phone call. Yes, and of course you have to give the device to the person to examine, and then him to certify that of course, yes, the conversation of so and so between so and so at such time, for so long, say for 15 minutes, has been recorded on such and such app in your phone. The details of your phone will be given. This is exactly the job of the expert who's certifying, because he will be questioned if it is not true.
So the next question arises is, when we talk about expert, how exactly does one go about identifying an expert? Do we simply search it on the internet, or is there any empanelment of such people who are generally easily reliable, or is it the third party forensic experts who provide such services?
Yes.
What
Yes.
is the mechanism to go about it?
Okay, so a person personally doesn't ever go through this. Most probably, when it is a forensic expert or a cyber expert, they are connected, like you said, empaneled is the right word. They are connected to certain government bodies. So in this case, police will help you, or certain agencies who are into certifying things may be able to guide you. So there is no one as such in the public, because you and me cannot do this kind of a certification job. Though we have maybe we have done some expert courses and degrees and whatever, but we have to get certain certification from the government, as per my understanding, to go ahead with this. This is not like notarizing a document, which is done by the advocate. But as you may be aware, not every advocate can notarize. So it's similar to that. And mostly, as far as criminal law and criminal trials are concerned, all this job is done by the police, and the experts put their opinion, their signatures, and that is again certified by the IO, that's the investigating officer. So it's not in general public. True.
What is the provision to prove WhatsApp chats and Facebook chats in family matters?
Say, for example, you have the WhatsApp chat. Yes, of course, in family matters, there's a lot of WhatsApp chats and Facebook and other recordings as well, which are produced in the court. So what happens is, you take screenshots, you take printouts, you get it authorized and certified from whoever person who's doing it, and produce it in the court. That's it.
So, but Sumedha, when one intends to submit screenshot as an evidence, any tips that you might have? Because I might just save your number as X's number and then have a screenshot with you, like have a chat with you, take a screenshot. Yeah.
That is the reason why the device, say for example, the phone, laptop, or the say tab, is given to the person, to the expert who is examining. So he's not certifying means what? He's actually going through the whole thing in your device, because that device can't be taken to the court. And then he's certifying. So the expert will know, he will go through the whole chat, or the whole WhatsApp itself. He will see what is all there in the device, and then he will certify.
When we email someone one entire WhatsApp chat, WhatsApp conversation, is that admissible, that email?
No, you have to have your device from whichever, like say for example, your laptop, you're sending an email now, so that can be your Gmail. Say for example, you have sent the emails from your Gmail, Google account. So the person will log in into your Google account. If some data is stored in your laptop or phone, then that device becomes important. But in email case, your Google account, your Hotmail account, that becomes important to the expert. So the expert will log into your account and try to get all relevant information with the help of certain software or certain processes that he has as an expert, and then take it and then produce that as evidence in the court. So
Okay.
that time the device will not be important. Say, for example, you have stored some photographs in your laptop or your phone, then that device will become important.
And lastly, Sumedha, many participants have requested or they want to know what are the career prospects in the field of electronic
Career
evidence.
prospects. Okay, so here as such, it is a part of criminal or civil litigation. I see it more in criminal litigation because people are suing each other for mental harassment and things like that with the help of WhatsApp chats. That's a simple thing that we come across in day-to-day life. Now, as far as career is concerned, I think you will come across this being a litigant, may it be civil or in criminal field. If you want to, then you can also be an expert in the matter. They say you can, have your own firm who certifies. So I was talking about this third party persons certifying the documents or the electronic records or evidences. I believe they can become a cyber expert. They have done a cyber course, or maybe a hacking expert who work with the government and government agencies who actually validate and certify the electronic evidence. So that I think is a very good career option. I have come across many forensic experts, cyber experts, and ethical hackers who work for the government. So you have to have certain certifications. You should have done some courses. I don't think law is very important over there, but there are few people who have done law as well because they understand the part of evidence in that case. And being an expert in itself is a career option. Or either the person can go for certification, becoming a third party who validates the electronic. But then you'll have to have an expert on the panel for sure.
Ma'am, you mentioned about putting this WhatsApp chats over like taking a screenshot and taking a printouts and then submitting to the court. What if we want to directly take the phone to the court and produce as a primary evidence?
No, phones are generally not taken. Pen drives are submitted, yes, in a sealed envelope, but phones are not. So basically, you will have to go through this process of getting it done from the expert. And only then, we taking screenshots and taking printouts is an easier way, but then, yes, of course, you need to validate it through the expert. And rather, the expert extracts information from your device and then he presents it in his own format. That's what I have seen, that, when police gives it as an evidence along with the chat sheet. So they do the needful.
So 65B4 is one thing and expert validation is another thing. So two things are the requirements, right?
No. 65B entails or talks about certification of the electronic record from authorized expert. No. Basically, sir, I would like to add that prosecution comes into picture only when it is with respect to state matters. But if it is a private warrant triable case, then I have seen people actually putting across a WhatsApp chat, printed what I was saying, screenshots and prints, and then getting it certified from authority. If it is a private warrant triable case.
If two persons' discussion is recorded in the voice recorder phone, then how to produce it in the court?
You have certain apps which can be downloaded on the phone, wherein the recording is being recorded, and you can transfer it. So now, again, you need somebody to do this. You can't do it on your own. You need the expert to transfer that data, that voice recording from your phone to a pen drive, which can be produced in the court, which can be submitted in the court as an evidence in an envelope. And also we will have to, since it's a voice recording, we will have to produce a transcript. Transcript simply means writing down whatever that you see or hear. So it's with respect to voice recordings, video recordings, which also include CCTV footages and all those kind of material, which can be seen and heard in a written format. That's a transcript.
This is
Hmm.
with respect to like some electronic device which has been confiscated or maybe has been seized by the police for the
Hmm.
so, is there any till the time that matter is not resolved or that judgment is not given, that
Hmm.
electronic device will be kept by the police, or there is some timeline that it has to be returned back to the individual, or
No, if the device is taken in custody by the police as an evidence, then you will get it back only after its use is over or the court directs the police to do so. Otherwise, you will have to wait for the trial to get over.
yeah, most of the time, like it is always remain with the police till the
Yeah,
time.
because there is a lapse. See, if the device is under question, then it will be retained by them. And secondly, the advocate of the person whose device it is has to put forth this question. If that evidence, if that device is not really important as an evidence, then the person should get it back. But otherwise, it will be lying with the prosecution as an evidence to avoid tampering of evidence. So, yes, mostly you will get it at the end of the trial and until they record it in whatever format that they want to present it in the court, submitting as an evidence.